I call this meeting of the House and Children and Family Affairs Subcommittee to order. Haley, would you please call the roll?
Vice Chair Bricken. Chairman Carter. Here. Vice Chair Eldridge. Here. Representative Gillespie. Here. Representative Harris. Here. Representative Stewart. Chairman Littleton.
Here. Thank you for that. Are there any personal orders today? Once again, I want to welcome my friend, Joan, look at me, Carter. Chairman Carter's lovely wife. We're glad that you're here, and we're glad that Chairman Carter is here as well. So today we have three bills that have been taken off notice. First, it's number 2, House Bill 1194 has been taken off notice. And then we have 2 that have been rolled. My apologies. Number 7, 1164, and number 8, 1166 have both been rolled. So first, the next bill was number 1, House Bill 140 by Lamberth.
I think that's my bill.
Is it? Yes, you are on that, Chairman Carter. Chairman Carter, you're recognized.
All right, thank you so much.
Do I hear a motion in a second? Do I hear a motion in a second?
Motion. Second.
Being properly motioned and second, you're recognized.
Thank you, Madam Chairman. This is a bill which corrects something that is pretty obvious once you consider it, but it hadn't been changed in many years. Currently, if you're in the TDOC or in a hospital, a mental health treatment facility, your venue for purpose of any hearing of any of your court matters is in Davidson County, Tennessee. People from East Tennessee, West Tennessee hospitals and prisons have to be brought to Nashville to have their cases heard. This bill simply says where you are housed or you're being your hospital treatment is being received, that county is the county which has venue for purposes of a conservator being appointed. There are currently 91 residents in the TDOC and mental health now who have conservators managing their affairs. Now they have to all come to Nashville and go back home, and that's an extreme disadvantage, expense-wise, time-wise, and just don't get a lot done. This bill will allow that conservator to be appointed. In fact, will require that conservator to be appointed in the county in which that person is housed at the time. I'll be happy to answer any statements.
Are there any questions for Chairman Carter? Questions been called for. Is there any objection? Seeing none, all those in favor of House Bill 140 say aye. Aye. Those opposed, no. House Bill 140 passes out to Civil Full. Next up, we have House Bill 723 by Representative Kaheen. Is there a motion and a second?
Motion. Second.
Properly motioned and second. Representative, you are recognized.
Thank you, Madam Chairman. I understand that the concerns that were expressed last week have been cleared up, and unless I can go through the bill again, whatever we need to do now.
Are there any questions for Representative? Hearing none. Are we ready to vote? Without objection, all those in favor of House Bill 723 say aye. Aye. Those opposed, no. The ayes have it. House Bill 723 moves out to full.
Thank you, Madam Chair and members.
Thank you for working with us.
Yes, ma'am.
Next, we have House Bill 326 by Chairman Moody.
Motion. Second.
Properly motioned and second. You are recognized.
Good afternoon. I think this is the first time I've gotten to appear before your committee.
Well, welcome.
Well, thank you, and thank you for all y'all do. Heavy subjects, but necessary. The bill I am carrying today, this is a victim-centered bill, and it protects a child from some questionable outcome in a civil custody battle. This bill gives the power to the victim of the rape and the child of the rape to decide when and if the child will be around the father. Present law removes parental rights from a rapist who is convicted of a crime, but this legislation would also remove parental rights from a rapist who is convicted of or pleads guilty or no contest to a lesser offense. And I think we would all agree that the victim of a rape and a child conceived of such an act should be protected from the perpetrator of the criminal act. And with that explanation, I'll take questions or ask for a yes.
I'm going to clarify one thing.
Yes.
If the mother so chooses, then the
Yes.
father can be in the line.
Yes.
Right. Are there any
Correct.
questions for Chairman Carter? You're recognized.
Thank you. Thank you, Madam Chairman, and thank you, Chairman Moody, for bringing this. I was concerned when I was a judge. I had a case of statutory rape where the people married and stayed married for, I think it was 11 years, and then divorced, and this issue was raised at that time. How would your bill deal with that?
That's a horrible question and a horrible situation. I would be glad to give you an answer. I
guess what I was saying is if the mother gives consent one time, unless there's some change in circumstances, can she withdraw that? I mean, I just thought it was bizarre that she would
Yes.
allege after 11 years that the man shouldn't see the child for
I
statutory rape. She was 17 at the time of the marriage. He was 22.
There in I don't know if this is the answer because have no legal mind hardly whatsoever, but I have on a page the code 366102. I don't know if any of those give you a direction. There's a part B that says the other parent of the child may waive the protection afforded under the subsection regarding visitation. And unless waived by the other parent, and if contributing towards support of the child, the Department of Human Services, a court shall establish a child support obligation.
Chairman Carter.
Thank you, and thank you, Michelle. It looks like it's just going to come down to what constitutes waiver.
Okay.
And so maybe a judge, after thinking 11 years of knowing this is his father's, constitutes a waiver. Your bill wouldn't do anything to prohibit something like that.
I don't think so, but I will,
Bad
if I find
facts.
out different,
Bad facts always make bad laws, so that's why I
Yes.
was wondering about it. Okay. All right,
thank you.
so much.
No, thank you.
Are you good, Chairman Carter?
I'm sorry.
Are you good with
No,
it?
I'm good,
Okay.
yes.
Are there any other questions for Chairman Moody? Hearing none, are we ready to vote? All those in favor of House Bill 326 moving out to civil pool, say aye. Those opposed, no. The ayes have it.
Thank you
Move
all.
out to civil pool. Next, we have House Bill 403 by Representative Carringer. Do we hear a motion and a second?
Motion. Second.
Been properly motioned and second. Representative Carringer, you are recognized. This is your second time in here. I didn't recognize you as a new member the first time, so I apologize for that. But you're going to have fun and enjoy this. I can tell that already. So you are recognized on House Bill 403.
Thank you so much, Chairman, and thank you to the members of this committee. I've tried to notify and get with as many as I could, and so I apologize if I missed some. I bring to you House Bill 403, and what this is it's going to make a small change to a bill that we passed in 2019. In 2019, the General Assembly allowed current members to opt in through the Department of Health vital records to serve as officiants and solemnize marriages in Tennessee. This bill simply allows current and former members of the General Assembly who opted in during their time in service to serve as officiants and solemnize marriages. There's no physical note that is significant, and no departments have raised any issues with this. and I have Department of Health to testify here if needed. Simply what, just to bring it down to just simple terms, is if you are a state legislator right now, you can go to the Department of Health and register to be able to marry people. After you are no longer a state elected representative, you cannot continue to marry individuals, couples. Now, I served as a Knox County Commissioner, and so therefore, for the rest of my God-given life, I can marry people if I so choose. But as a state representative, only while you are active as a state representative, and if you have signed up through the Department of Health, you can marry. But as soon as you're not a state rep, you can no longer. So what this would allow is that as long as you register with the Department of Health, even after you're not a state representative, you could marry people. So that's what this bill is pretty much all about. So we're here to answer any questions or whatever concerns anyone may have.
Oh, there are questions. Are you guys wanting to marry people? Vice Chair Brecken, you are recognized.
I don't have any trouble with the legislation at all. I'm just not sure really if it's needed. And it might be a legal question. I've married people. I was a county commissioner. My wife has married citizens in this state, and she has never been elected anything. And those marriages have all been legalized. So I don't know what this, I think any citizen properly witnessed can marry in Tennessee. So I'm not 100% certain, but I know one lady that can.
So do we need to go out of session to get that answered, do you think? Michelle, or do you have anything? Okay, we are out of session.
Michelle Fogarty, Office of Legal Services. Tennessee Code Annotated 36-3-301 specifically lists persons who are able to officiate marriage ceremonies legally within the state of Tennessee. And so this is just adding to that list. If you're already on the list in this statute, then you can lawfully solemnize a marriage in this state.
Maybe I can, excuse me, thank you.
You're recognized.
You mean just get on a list?
Well, no, there are certain persons and, like, for instance, the governor, the Speaker of the Senate, former Speakers of the Senate, Speaker of the House of Representatives, former Speakers of the House, members of the current members of the General Assembly, the county clerk for each county, former county clerks for the state.
Pardon me, and obviously there is a list of officials. I'm just saying, what is the general marriage law rules about just being married, a legitimate marriage being recognized in Tennessee of the union of two people conducted in publicly with someone that's not, quote, on the official list?
Okay, then it must be performed by someone who is authorized under this statute to perform the ceremony, which also includes any minister, preacher, pastor, priest, rabbi, or other spiritual leader who's ordained or otherwise designated in conformity with the customs of a church, a temple, or other religious group or organization. So in order to be lawfully able to solemnize marriages, you must fall within this statute.
At one time, was it not legal to get it online for a short amount of time?
There's some court cases regarding online, or people who become ministers online. There are some court cases that address whether or not those marriages are valid in this state. And in some instances, they have been found to not be valid because the person didn't fall within the statute as a minister ordained or otherwise designated in conformity with the customs of the church, temple, or religious group or organization.
Chair Bricken, do you have any more
I think
questions?
she took an online course.
Uh-oh.
Well, anyway, I just think that, I'm just always question about the need to to legislate a lot of things, and that's.
Are there any other questions for legal? Hearing none, we'll go back into session. Representative Harris, you're recognized.
Yes, thank you so much, Chairwoman. So, Representative Carringer, I just wanted to say I did not know that we could do that as a new member, that was even possible. So thank you for bringing that to light, but also great job. I've been watching over the last couple of days, and you've done some really good work outside of this one as well. So, but I will be supporting it.
Thank you, my fellow freshmen.
Are there any other questions for Representative Carrigan? Hearing none, are we ready to vote? All those in favor of House Bill 403, moving out to civil full, say aye. Those opposed, no. The ayes have it. You move out to civil full.
Thank you so much, Chairman, and thank you to your wonderful board.
Thank you.
Thank you all.
So next we have House Bill 104 by Representative Parkinson. Thought I saw him. Okay, well, we will roll him down 2 spaces then. House Bill 1164 by Representative Harris has been rolled 1 week. And number 8, House Bill 1166 by Representative Harris has been rolled 1 week. So next we have number 9, House Bill 1168 by Representative Harris. Properly motioned and second. Representative Harris, you are recognized.
Great, thank you so much.
And I don't believe in hazing, but I do think this is your first bill in
This
here.
is my first bill, so that's the reason I came down instead of doing it from my
There
seat.
you go. Okay, so you're recognized.
Thank you, thank you. All right. All right, and so thank you again, Chair Lady, and to the committee for being so gracious to hear this bill. House Bill 1168 amends Tennessee Code annotated Title 36 and 37, and as introduced, prohibits a court from solemnly or solely considering a parent's disability to determine custody unless it impacts the parent's ability to meet the need of the child, and specifies that a court cannot consider a parent or guardian's disability alone in a termination of a parental rights proceeding unless it impacts the physical or psychological welfare of the child. We're all aware of the Americans with Disabilities Act of 1990, which has been law of the land for nearly a quarter of a century. We expect to accommodate people with handicaps. We anticipate working side by side with disabled coworkers. We raise our families in the same neighborhoods and send our children to the same schools. But our courts do not always extend the same level of inclusiveness when it comes to granting child custody or visitation to a disabled parent. In fact, we are one of the few states that go above what ADA mandates, and in current code, it states that the disability of a parent may be a factor to be considered by the court in awarding custody to another party. Although the ADA mandates equal access to the court, once in state family court system, a parent's disability could be used by the other parent as a weapon for custody, visitation, or even as far as for parental termination. A survey that was conducted showed that even in the last 2 years, over 100 complaints of possible disability discrimination by a Tennessee court were submitted for review, and the National Council on Disability published its concern about the legal battles that disabled parents, many of whom are military veterans, encounter routinely in family court. The facts are the facts. Disabled parents who divorce are far more likely to lose custody of their children. Furthermore, most cognizant disabled mothers and fathers are likely to lose a custody challenge. This legislation is very personal for me. I have a sister who was like a mother to me growing up. She's 15 years older than myself, and she went off to some of the best schools and best colleges, had an amazing job, and is a single parent. And she also has a little girl who is my niece. My sister fell ill all of a sudden a few years back actually, without any type of warning signs. Her disabilities now require some assistance from my amazing mother and grandmother, but it has not stopped from raising my niece to be the best that she can be, and from being cared for and loved. I feel very confident in saying that my niece has to be one of the brightest young people I know, and it's not just because she has a pretty smart uncle like myself, But my family and I would be devastated if ever the court was to make a decision of custody because, as it is stated in our current code, disability of a parent may be a factor in awarding custody to another party. I also have a letter that I've given to most of the members as well in support from the Tennessee Disability Coalition, support from the ARC of Tennessee. I had a conversation with a couple of disability attorneys from the Disability Policy Alliance, and I hope that I can also ask for the support from this committee as well on this legislation. And so with that, I yield back to the chair.
Yeah, I do have one question. The best interest of the child will still be.
Absolutely. So if it affects the physical or psychological welfare of the child, then custody could be considered when it comes to disability.
All right. Are there any questions for Representative Harris? Representative Gillespie, you're recognized.
Thank you, Madam Chair. To my fellow freshmen, thank you for presenting this. I'm not sure if I misunderstood you, and I completely okay with everything. I'm just curious if we have the Americans with Disability Act, and this may be a question for legal. How is it that this is already happening? How are we not in compliance, or did I misunderstand that? Thank you.
We'll go out of session for legal. Michelle, you're recognized.
Michelle Fogarty, Legal Service. I think under the ADA, it can't be the sole reason for a person's disability can't be a sole reason for determining custody. And I think, I don't know that this particular subsection has ever been challenged in courts, and I don't know that a court's had a chance to rule on whether or not it falls within that.
Back in session. Are there any other questions for Representative Harris? Hearing none, are we ready to vote? Without objection, all those in favor of House Bill 1168 moving out to civil full, say aye. Aye. Those opposed, no. The ayes have it.
Thank you,
Move
committee.
out to civil full. Now we will go back to House Bill 104 by Representative Parkinson. Motion. Proper motion and second. Representative Parkinson, you will be recognized.
Thank you, committee. There's an amendment on the bill that actually rewrites the bill.
And what was that number?
That number is, probably should put my glasses on.
Probably. I feel your pain.
Let's see. Thank you, Madam Chair. That number is 03691.
Okay. Would you like to?
Yes, ma'am. And what this amendment does is it removes the 5-year statute of limitation for challenging a voluntary acknowledgement of paternity, and it allows for non-court ordered DNA tests from accredited testing labs for admission as evidence in future court appearances.
Okay, we need a motion and a second on the amendment. Properly motion and second. Are there any questions on Amendment 3691? Hearing none, all those in favor of putting Amendment 3691 onto House Bill 104, say aye. Those opposed, no. The ayes have it. Yes, you're recognized.
Thank you, Madam Chair. You know, it's interesting. This is actually a path that myself and Chairman Carter, we started some years back, are looking at, you know, some of the child support legislation, and how this came about was because there was an individual in the, I'm sorry, y'all. There was an individual in the barbershop that came to me and said, hey, I found out a child was not mine, and I went to court to get the child support removed. And the magistrate or the judge said, somebody's got to pay for it. And he said, you're going to be paying for him for the next 18 years. And he found out by DNA that it wasn't his child. And what this bill does, and I've talked to Department of Human Services about this too, and you know, they're deferred on the bill, so they're okay. What this bill does is just, right now under state law, you only have 5 years to you know, petition the courts to reverse that. And that's what happened to him. He was caught at, the child was 5 years and 2 months. and the judge made him continue to pay for it. And what happened with him subsequently is he lost his driver's license, was incarcerated, lost his job, and his entire life has been wrecked because of that. And so what this does is it removes that 5-year statute of limitation, and it allows individuals to go get a DNA test without it being court ordered, but from an accredited lab that the courts will accept.
Are there any questions for Representative Parkinson? Seeing none, are we ready to vote? All those in favor of House Bill 104 as amended, say aye. Aye. Those opposed, no. The ayes have it. House Bill 104 as amended moves to civil full.
Thank you, Chair Lady Littleton. Thank you, committee.
Next, we have number 10, House Bill 200 by Chairman Carter. Chairman Carter, you're recognized. We need a motion and a second? Properly motioned and second, recognized.
Thank you. Many adoptions are, of course, consensual and are joyful times. Sometimes they're not, and sometimes it involves the forceful termination of a parent's rights in order for that child to be allowed to be adopted. As lawyers, being one, I can say this, and having friends in the audience who are lawyers, I can say this. We try to be so specific with so many things we do. So we have a statute which lists, I think, 9 reasons why you can terminate a child or a parent's rights to a child. What has happened over the years is that's turned into 9 very detailed explanations, arguments. Many times the courts will say, wow, that's close, but it's not exactly what the statute says. I ran into this some years ago, and a good friend of mine back in Chattanooga that only does adoptions, and saw him one night, and we began to discuss it. It seems to me that regardless of the wordsmanship in the statute, what should be considered is the best interest of the child. If you can take 2 or 3 of these and put them together and they're almost enough to terminate the child's rights, but they're not exactly what the statute says, then that child is going to remain in the situation they're in. This statute simply says that a judge can look at the 9 factors now, but they're not exclusive. The judge can look at them, can combine them if necessary, or can make up one. In every case that we see, there's always something odd about a decision or a case. So frequently, when a case comes up that none of the 9 apply, it's just an odd case, then where that is no grounds to remove child custody or to extinguish parental rights, I should say. Now, my bill would allow the courts to say that it is in the manifest best interest of the child that the child be removed from this parental situation because of these factors, and the judge must state what those factors are. Currently, under the law, if they're not included virtually verbatim in the 9, then it is not a reason. So what we're doing is going from a list of what lawyers think are a good reason to have removed children from parental situations disadvantageous to them. We're saying now that the paramount rule in this case from this day forward, or the passage of this statute, will be the guidance given by those, but the best interest of the child, being the manifest best interest, will control. And if none of the 9 even touch on it, but the judge is so moved as to want to remove the parental rights of the child because of that, he or she can state those on the record, explain them in detail, and say that the best interest of the child requires and mandates a removal of the parental rights and shall be able to do so. Currently, under the law, they cannot. So, we're moving from detail and detail and detail to best interest of the child. We're very fortunate here today to have a gentleman here who I don't know, but as often in life we find he's the best friend of a best friend of mine. To that, he's spent his entire life doing this. He has forgotten more about adoptions than I've ever known. By the way, I never handled a single adoption in my life, so I should not be considered authority. But knowing Mike Jennings and the other people who do this, they frequently bring bills to me, and the state of Tennessee has moved very dramatically forward in the past 4 or 5 years by you all's efforts and the bills that you've brought to this body, and so I very much appreciate that. So I would like for him, if it's okay, to take a few minutes and let him better explain what I've just tried to explain and answer any questions that you might have.
Without objection, we'll go out of session. If you could come forward and state your name, make sure the microphone is on, and yes, just state your name and who you are.
Afternoon. I'm Kevin Weaver. I'm a practicing attorney in Memphis, Tennessee. My practice is primarily adoption law. Been doing it for almost 35 years now, and probably have done hundreds and hundreds of termination cases that the representative was talking about. I currently am the chair of the adoption section of the Tennessee Bar Association, and so that's why I'm here today. That section is a group of attorneys from across the state. I don't know the number. I would say there's over 30 or so in that section, but primarily they do adoption work. This proposed bill that's been introduced by Representative Carter is one that came out of that group and was approved by the Board of Governors of the TBA. I do have a PowerPoint. It wouldn't take long to go through it. I don't know if I will say that this bill, what it does is you have, in termination cases, you have two prongs. You have to show grounds, and you have to show it's in the best interest of the child. This particular bill addresses the best interest aspects of it. That section of the bill was originally drafted and approved by this legislature in 1996, a quarter of a century ago. It's really not been touched as far as the list of best interest factors. What this bill does is it does several things. One, it recognizes over the last quarter of a century that there has been a dramatic improvement in understanding children and the minds of children and the welfare of children. And this bill incorporates a lot of that study that's been done by doctors and by specialists to expand the factors to consider when you're looking at best interest. Currently, like as Representative said, there are 9 factors. And currently under the law, a judge has to look at those factors, and he has to address every single one of them in every termination case he or she does. What this bill does is it expands the factors, which is always something you got to think about. Do we want more or less? But what it does is expands, but it recognizes that you have to look at more than just the safety of a child when you're looking at best interest in a permanent placement. It's safety, it's stability. It recognizes those things, but more importantly, what it does is it says to the trier of fact that this is a list that will help you conceptualize as you're hearing this case, what are the best interests I need to be looking at in this case? But it doesn't lock down that trier of fact to have to go through every one of those factors and say, this one applies, this one doesn't apply, this one applies. It allows discretion of that court. And it also, as Representative Carter said, if there's factors that aren't on this list, the court can go to those factors as well. But it does say that whatever factors the court does consider, they have to put in their order those factors and how the facts apply to them. Because one thing that the general public doesn't understand until you get one of these cases, an order that comes out of a termination case, I've I've not drafted one that was less than probably 12 or 15 pages long. It's findings of facts, it's conclusions of law. And so this bill really gives two things for the judge, for the trier of fact. One, it expands what they can look at, to give them ideas of what they can look at, incorporating the latest law on children's welfare and what's psychologically goes through a child's mind. And two, that you're not bound by any one of those factors. You can go outside those factors. That's the primary essence of this bill. I believe it's needed. I've done hundreds of these cases, and over the years, I have seen factors, I have seen fact situations that didn't exactly apply to the best interest factors that were there, and you could see the trier of fact really struggling with how to deal with that. This really gives them some well-equipped tools to really address that best interest, because at the end of the day, no matter what you do with the child in adoption, whether it's voluntary or involuntary, the primary purpose of the statute says what's in the best interest of that child. Our group strongly believes this recognizes that and believes it would very much enhance the adoption law in Tennessee.
Thank you, Mr. Weaver. We're going to go back into session. No, we're going to see if anyone has questions for you, and then we're going to vote on the bill, and then we'd like to see your presentation. That's okay.
Okay.
But if you could maybe answer a few questions.
Sure, absolutely.
Does anyone have any questions for Mr. Weaver? Well, here, then are we ready to vote for House Bill? Oh, we need to go back into session. So we're back in session. So all those in favor of House Bill 200, say aye. Aye. Those opposed, no. The ayes have it. House Bill 200 moves out to civil full. Now we're going to go back out of session so that you can show your presentation. So we are out of session.
And Chairman, I appreciate
you.
it. This won't take very long.
Yes, and thank you for being here. And I think this is like, I know that we want every family.
What are you going to say?
I know we want every family to stay together, but we know they can't always do that. So we look forward to your presentation.
Thank you. What you're about to see is really a summary of what I just talked about. Let me here on these controls. Okay. I've always believed that understanding something like this is just get it in context. So, in the adoption world, what is it? Legal establishment relationship of parent and child between as if the child was born to them. It's interesting to note that in the adoption area, there are a number of people in this state that really confuse custody and adoption. And so this is the legal relationship, changes the birth certificate. In order for that to happen, the child must be available for adoption. The child must be in a legal status that child can be adopted. Which means you have to terminate in some way the parental rights of the parent. Now, you can do that in three ways in Tennessee. You have voluntary surrenders of parental rights, which, by the way, this state is a state that does that by judicial surrender, which is, there aren't a lot of states that do that. I think that is an excellent way to deal with voluntary surrenders. Involuntary terminations can occur in Chancery Circuit or juvenile court. So when I talk about trier of facts, we're talking about every judge in this state just about, except on the criminal side, can do termination of parental rights. So it's it's going to touch almost every judge in the state. Or the death of a parent. That's another way that happens. The procedures, a judge must find grounds for termination as well as terminations in child's best interest. Both of those are codified in the legislature. And in 1996, which I mentioned before, the legislature completely overhauled the adoption law in Tennessee. It was a mammoth work, and to this day it still is solid. It's really, really good. So the codification is grounds, and there are a number of grounds that can be applied in the state of Tennessee to terminate parental rights. But once you find, so you have to find grounds before you can rule on the best interest. So the way the law works is you have to establish that at least one ground exists, and then you have to look at best interest. That's where these factors come into play. And the purpose of this legislation, it revises the best interest factors that were codified 25 years ago. Current limitations, the current factors focus more on birth parents than they do the child. It focuses on primary need of the child considered as physical safety, which this amendment, this proposed bill completely recognizes that. We're not saying that's not important. But it also highlights that over the years that there are situations not considered by the factors or places where considerations were too broadly or narrowly drawn. And this legislation allows that to change. Doctors have learned a lot more about what young children need to be healthy. The proposed legislation incorporates trends in the child welfare law since 1996. One, that children need a safe home very early in life when they can form stable attachments. And two, that those attachments, once created, should only be disrupted by compelling reasons. And it would clarify a couple of things. The judges have discretion to apply only the best interest factors that apply in that particular case. But they are not limited to considering only those factors listed in the legislation. That's what this bill is about. Short and sweet.
Thank you very much for that. It was short and sweet, and that's the way we like it. But it was very informative, too, so we really appreciate you being here. So are there any questions?
I'd just like to thank you for coming.
Absolutely.
Yes,
We really appreciate it. I know you've worked hard on it, and we appreciate Chairman Carter working on it as well. We say around here he's the man for the adoption bills, so he does a great job.
We've got his hotline. We got the Batman
There you
hotline
go.
for him
There
on
you go.
this.
Thank you so much for being here. We really appreciate it. So
Thank you.
thank you. So we're going to go back into session. Next week, we're going to have Matt Stowe, the district attorney for the 24th Judicial District, and he will join us for a presentation. Are there any other announcements before we go? Do I hear a motion for adjournment? We are adjourned.